for joining us. It's great to be here. My name's Jacqueline, and I'll be your moderator today as we discuss protecting medical and elderly wishes. Brought to you by your esteemed ACC, a community of caring. As you listen, please think of any questions that you may have, because we'll have an opportunity at the end to go over them. Our professional panel is right here, and it consists of Melissa Yee Law. She is an elder law attorney with Yee Law Group, and Michael Yee is an attorney also. He specializes in estate law with Yee Law Group, and their father, Alan Yee, is a pulmonary specialist with Pulmonary Medical Associates.
Thank you, Jacqueline. I'm pleased to be back. It's been several years since I spoke to this group about making your wishes known when entering a medical facility. I have served as both a medical director of the ICU as well as subacute care unit at Sutter Medical Center, Sacramento. In these roles, I hope to bring to you some insights on what decisions a family may need to make when entering these facilities.
Hi, thank you for the introduction. I've always had a desire to work with the elderly, as I used to volunteer at the Asian nursing home when my great-grandmother was a resident there. And also later, I worked in the administration building at ACC when it was in its early years.
Thank you.
Yeah, it's also great to be back as well. I did a presentation a few years ago on So You're a Trustee, Now What? And now I'm back with my sister and my father, so it's great to be here as well. So.
Great to have you all. So I'll start off with Dr. Yee. Is it true you should have both a POLST form and an advance directive? And what's the difference between these two?
Well, let me start off by explaining what an advanced health care directive is. It's also known as a living will. This is a legal document that gives guidance to the medical staff and facilities. It gives guidance on who is empowered to speak for you if you're unable to speak for yourself, and also has some probably a few extra things about what you want or don't want to have done. But was later developed a POLST form. This was found in the 1990s that living wills did not give enough clarification to the medical staff on what a person would want or would not want done. And in fact, about that time, the U.S. government decided that all facilities receiving Medicare dollars would need to ask that individual entering the hospital whether or not they would want CPR or what type of life-sustaining treatments they would want. And in fact, in 2009, California passed a law requiring that there would be called a POLST form. This stands for Physician-Ordered Life-Sustaining Treatment. This includes basically three major points when you're entering the hospital. Point one would be whether or not you would want CPR. Point two is how much medical care you would want done. And the third thing is what type of nutrition you would want done if you're unable to eat or swallow on your own. Typically requires, it refers to whether or not you want some type of feeding tube placed in you and how long. These documents need to be signed by a medical professional as well as the patient, so it becomes a physician order. While like I said, a advanced health corrective is the legal document allowing that person to designate someone to speak for them if they're unable to speak for themselves, and may alter what they're someone that the physicians can talk to if you're unable to just talk for yourself.
So the POLST form is a form that I can fill out with my physician, and it's something that I would update and change as I age.
Yeah. So both actually are complementary to each other. It's good to have both of them, but if you have one or the other, that's helpful. And even if you don't have neither, physicians need to work with the closest spouse to try to work it out. But the importance is that sometimes family members or spouses always wish for a person to have everything done. Obviously, when their loved one comes to the hospital, your first thought is do everything possible to keep them alive or help them. Occasionally, though, family members, a spouse or siblings may disagree on how much they would want done. And that's where it's important to have the durable power of attorney, the living will, designating this person will speak for me. They understand my wishes, what I want done if my time came that I would need some medical care. Also, since the 1990s, when Medicare had asked the hospitals to ask that question, anytime you admitted to the hospital, even though it's maybe for something minor, such as a sprain or even ankle injuries, such as when you're playing pickleball, you're asked that question. When you show up in the emergency room, they'll always ask you, if your heart should stop, if your breathing should stop, would you want CPR? Would you want to be intubated, meaning a tube placed in your throat to keep you alive? Even if it's something as minor as, like I said, a sprain, because we're authorized or we're required by law to ask those questions. So a person may say, wow, I didn't know I was that seriously ill just coming in for just a sprain or a minor surgery, but hospitals are required to ask that question. It doesn't mean that you're going to have those things done, but just in case.
It's good to know. So we always hear avoid probate, avoid probate, avoid probate. How do we do this, and why do we want to do this?
Okay. So as an elder law attorney, my area encompasses a wide array of issues, and probate falls under that. I think my area of law fits nicely with our firm, as I tell our friends and family, if you don't use my brother's services, then you'll have to be coming to me. Generally, I'll explain what probate entails. A probate is a court procedure that is used to oversee the division of assets of someone who has passed away. It is typically needed when a person does not fund their assets in a trust. And I just want to let you know that a will does not avoid probate. Some may wish to avoid probate because it is a lengthy and expensive and very public process. But sometimes it is necessary, though, if there is a dispute within the family, or there are a lot of creditors involved, or maybe court oversight for a family may be necessary. So a lot of times people do wish to avoid probate, though, because of the nature of how long it's going to take to divide a person's assets, and then just the expense. And a lot of people don't want to have their family's financial information made public, through a court procedure.
The conservatorship, and when do people typically come to you seeking a conservatorship?
Okay, so I will kind of discuss when a conservatorship may be necessary. So a conservatorship is a court procedure when a judge appoints a conservator to oversee the financial affairs and the health affairs of an individual. A conservatorship has been very helpful to many of my clients to help protect a loved one, but it is a very complicated and lengthy procedure. So it's something that a lot of people do want to avoid, but it can become very necessary. Conservatorships are a great way to protect a loved one, a family member that is experiencing health issues and also financial distress. But a conservatorship can be avoided sometimes with a trust or power of attorney. So I tell my clients that conservatorship is sometimes kind of a last resort measure that will be necessary for their loved ones if they don't do any pre-planning. A conservatorship is established by the court when it is deemed that a person cannot provide for their food, shelter, or clothing, and cannot avoid undue influence or fraud. So, like I said, it is a lengthy procedure. It's complicated, but it is very rewarding for me as an elder law attorney. I am there for a family member to help protect their loved ones when they're really in distress. And that's why I like being an elder law attorney. And that's kind of summarizing what a conservatorship is.
Thank you. So it sounds like planning is very important. If I already have a will in place, I'm sure a lot of people come to you, Mike, and say, if I have a will, do I also need a trust? And it sounds like maybe they do. What's the difference between the two?
Yeah, like my sister was saying, if you do have a will that is still overseen by a judge, so basically someone brings that will to court and has to get processed, and then the judge oversees it, and the state gets involved, so it does take a lot more time, expense to get that done. And a trust is sort of like a will. I think a lot of people are familiar with more wills because they hear about it in movies and so forth. So a trust sort of has the same effect where you could direct where you want your assets to go and who's going to be in charge. I think the state just made a distinction between the two, where a trust is typically drawn up with attorneys, so it's more formalized. A lot of times it's notarized. Versus a will, that could be witnessed a lot of time. So that's the main distinction. Will, the state still said you had to take that will to court to get processed, where a trust, a lot of times that's done privately where you don't need a court involved. So.
Got you. Okay, so if you have only a will, you have to go to probate, and wills aren't notarized, so that can get a little complicated.
Yeah, so I think they just want to ensure that that will.
Sounds like extra protection.
Yeah.
Okay. So when should someone get their estate planning done?
Yeah, I mean, that is a typical question I get asked a lot. So when I get people in my office, they say, is now a good time to get done? Yeah, I'm always the firm believer in just getting something in place, no matter what age group you are. At times I get new parents with minor children, and they just want to make sure, someone's able to take care of the children if something happens to them. Probably the next stage in life, I see, a married couple that have adult children, and now they're like, oh, I waited 20 years, but now I think I should get something in place. And then probably at the very end, I see a lot of age group 2 where, they really should have got something done, but now they're just, their children are helping them get something in place, so they want to ensure that makes it easier on them. So those are probably the 3 main groups I've seen, but yeah, you should probably get it done as soon as you can.
As soon as I can. So can I just come in and get started, or do I need to run around and collect a bunch of documents? That sounds a little stressful.
I do get a lot of people where I thought this was going to be a super complicated process, and they are relieved a lot of time when they get in, and we have, the main things to think about for them are who's going to be in charge of their estate. So that's the main component, like who's going to actually handle this when they're passed away, and then where their assets are going. So yeah, I mean, it is important to figure out, what accounts you have and what property, but those aren't the main things that you really need to have at the meeting or moving forward. It's more who's going to be in charge and then where your assets going. So just, plan some of those things out.
Okay, that doesn't sound as complicated.
Yeah.
So once the trust is created, how do I maintain that? If I buy a house, if I open up bank accounts, do I need to return to the attorney and pay them to have these documents amended? That sounds expensive.
Yeah, that is a lot of fears and holding people back. They're worried, if they set this up, life is going to change. They might have more children, or they might, buy more property or add more accounts. And a trust is honestly a really flexible document. A lot of times you're just saying, you want your assets to go equally to your children or these typical family members. And if you're just adding and subtracting assets to your trust, as long as that distribution pattern doesn't change over time, you don't really need to come back to the attorney to constantly amend the documents if you're just adding, subtracting assets. Typical changes would normally be if you're just changing who's going to be in charge of your trust or where those assets are going. So yeah, there isn't really a maintenance fee or a lot of expense every time something changes. So it is a highly flexible document.
Okay, good to know. We did receive an emailed question before our discussion, and I think Melissa might be able to help us. I'm sure a lot of people ask you elderly care related questions, and this person has a mother who's in a care home and they're currently paying out of pocket, and they're wondering what resources there are for them to reach out to see if they are going to qualify for Medi-Cal assistance.
Yes. So unfortunately, as everyone knows, assisted living, nursing home care, it is very expensive, ongoing expense. Unfortunately, so Medi-Cal itself is kind of a poverty level program. You have to qualify based on your income and assets. And the government has made a decision, though, it would like, it'd be nice if the government could provide for all the elderly who don't have that many assets. Unfortunately, right now, though, the main program is Medi-Cal long-term care. So that's a program that's mainly only going to cover nursing home care. There is a small program, a waiver pilot program that covers some assisted living, but it's a very small program right now. So unfortunately, even though assisted living is a wonderful thing for the elderly so that they don't have to go to a higher level care if they don't need it, Medi-Cal really does not cover that many people in assisted living. So you could go to the Department of Healthcare Services website. It does explain the waiver pilot program, but unfortunately at this time, it just really doesn't take that many applicants. So the main program, though, is Medi-Cal long-term care. So that would be for the nursing home care. That the government does help a lot more of the elderly who can't afford nursing home care.
So when I have my pulse form and my important documents, is there anywhere special I should keep these documents? Dr. Allen Yee?
Well, yes. Typically, these forms, once they're filled out, they are generally given to your primary care physician. And with the world of electronic medical records, it becomes a little easier because these forms are often in your health care forms that are electronically put into your records in, say, like a hospital and things along that line. But also, they recommend that you keep them available in a designated spot that some family members will know about. And if your health care is more toward the end of life, sometimes you tape it to your back door where, emergency medical team, if you call them to bring you to the hospital, are easily able to find them. And as probably very recommended, these forms are always, as well as your will, your trust, always need to be reviewed because your health care changes over time. The forms that I fill out now, when you feel like you're young, you're in a good state of health, may change over the years if you have some type of medical issues that are no longer easily treatable. You may change those things. And sometimes your living will or your advanced health care directive, the person you designate that to speak for you may pass away or has some health issues themselves. And so sometimes you need to change who's going to speak for you. And also as part of these forms, which is as part of this whole movement of letting people know what you want done when you're become elderly or even some people who are young in health. You often read about some people at 46 years old developing some type of medical issue, having some type of serious stroke. You need to sit down and write what they've discussed now is called the 5 Wishes. That's a new campaign that was actually helped develop by Mother Teresa, who, when she's in Calcutta, she worked with some people to create what they call the 5 Wishes campaign. And this is not per se a specific medically document, but it's something that people come up with. And those wishes are, who do I want to help make decisions for me when I can't? What type of medical treatment do I want or don't want? How comfortable do I want to be? And how I want people to treat me, and what do I want my loved ones to know? This is a document that says basically, what was my life goal? The last question is, what do I want to be done to myself? Where do I actually want to be buried? This is something that's very interesting because some people don't make that information known to their family members, and they're often left guessing what you want done in that final time. So it's important to make this type of living will. And explain also, it's nice to let your family know what your life goals were. What were your hopes and dreams for them when you're no longer able to tell them? And I think that's something very important that we all need to look at and think about, letting your loved ones know how you want to live your life and what you want them to know about you.
Yeah, we plan so much and we customize so many things, but oftentimes I think a lot of people maybe think that they're never going to die, so they avoid these things. I heard that, so you should tape it to the door and not put it in the freezer. Someone told me that you should put this form in the freezer.
Well, actually, that's what one person, told my father. You could store.
Really?
You could store this thing in your freezer, but at least, you need to tell people where you put things because, again, if you put them in the bottom of a sock drawer or something like that, they're not going to find them. But at least, it gives a person, a place to look.
Sounds good. So we need to communicate with...
Often while you do have a pulse form, sometimes people do mention or complain, wow, I had a pulse form telling people I didn't want anything done, but when I was brought to the hospital, they put my loved one on a life support, because emergency rooms are required typically, unless they know right ahead, to do everything possible. And until that person has that pulse form brought up, then you can make further clarifications. But in the split-second decision-making, they're not going to spend 5 minutes trying to go through some type of electronic chart, finding out who you are, what you want done or don't want done. They need to err on the side of doing everything possible.
So it's important to plan ahead, communicate our wishes, make these documents available, have them in obvious places, fill it out with our physician, and make sure that we understand what these things are. I don't really know, if I needed a feeding tube, I don't know what that all entails. So that's a conversation I would need to have with
So
the
that's
doctor.
where, before you fill out a pulse form, it requires a medical professional to discuss what those points mean, whether or not you have a feeding tube. Sometimes these tubes are placed through the nose, through the mouth, it goes directly into your stomach. Or some people who, say, had a stroke or have some type of disease, like something like Parkinson's disease, where you're not able to swallow on your own. Some people actually have designated to have a tube directly placed through their stomach wall into their stomach, so they have direct feeding that way.
There are a lot of options.
A lot of
I'm glad I
options,
don't have to choose
a lot
that
of
right now.
clarifications where
Yes.
people just can't be handed these forms. And I brought, everyone sees these pink forms. They are in English, but if you look, they're in multiple languages. They can be in Chinese, Tagalog, Korean, multiple language, Hindi. So these things have been developed so they have multiple languages, so they can be easily understood by non-English speaking people, but always need to be clarified or gone over by some medical professional who could explain to you what a feeding tube means, what CPR means. And also, some people may have a pulse form saying they don't want CPR, but if you're admitted to the hospital, some people may ask you, well, can we reverse it individually? Or so you may be admitted and you have some type of terminal disease, but you come in for something minor, such as appendicitis, where they may want to do minor surgery, or even a broken leg, and they say, look, we need to take you to the operating room and put you to sleep to get that procedure done, and we may put you on life supports for a brief period of time. But that's where you need to be able to sit down and talk with that individual, or you have that person who is that living will or that durable power of attorney for health care reasons, explain to them this is something that can be fixed and hopefully return you to your state of health.
So yeah, all these documents are changeable breathing documents that if something like that came up, I could say, I want to change my mind with my pulse form. I do want to have the surgery. Okay. So as far as with a trust, where should people store that, Mike?
A lot of times I recommend just storing it in a safe place like mine's in my office and just letting your successor trustee, whoever's in charge, know where it's located. Also, each attorney's office normally keeps a backup safe, so that's always a good starting point. And then, we recommend, like my father was saying, letting your advanced healthcare directive, just registering that at your hospital or your primary care physician, so they have that on record. I'm just curious, though, how does that actually work? So let's say someone's brought in the hospital and they don't have capacity. Who does the physicians know to speak to make medical choices? Like, do they go on the record, or how does that normally play out?
If you arrive in the hospital and you're unable to speak for yourself and you don't have a previously done pulse form or a living will or someone who is designated to speak for you, typically the social worker, we work with them finding your closest relative. Typically you'll look for the spouse, or then you may look at the siblings, and there it is, the hierarchy of the oldest sibling speaks, and then we've looked at even aunts and uncles. Sometimes occasionally it becomes very complicated if the only relative is, say, like a aunt that hasn't seen that relative in 20 years or spoke with them, and that's the closest living relative. And there's where the doctor may sit down and discuss, well, what is the medical decision? Is it something that they're going to pull through from? They'll try to work with that person, and occasionally the family member may then turn around and say, look, I don't feel like I can make a decision. I'll leave it up to the doctors to kind of decide what's going on, and then based upon whether or not the type of illness they present with is something that can be corrected and treated and return that person to a normal or a previous state of health versus something that is maybe they have a terminal illness, and it's best that we let them go as comfortably as possible.
Got it. Okay, good to know.
Do we have any questions from anyone online or anyone in person?
Can you hear me?
Yes.
This is Raul Moreno, and I just wanted to ask in general of our attorney folks here, are you by any chance members of the ARAG group? ARAG? I belong to that group through CalPERS, and I was just wondering, are you part of that group or someone that can work with that group?
Yeah, that's a great question. We do get that question sometimes, and unfortunately not at this time. We're mainly with MetLife, so I know it's another legal plan. A lot of employers offer that, like through Sutter. I know I work with a lot of my father's employees that they have there, but unfortunately not ARAG at this time.
But that is a
Okay.
great question, because there are actually a lot of people that don't realize they have plans that can cover this through their work.
Yeah, no, that's correct. Yeah, a lot of times people, like Jacqueline was saying, they have these legal plans through work, and they'll actually cover all these documents. So there's no really downside to getting it done if it's all covered. But I know there is a lot of good attorneys through ARAG that could help as well.
Thank you. Do we have any other questions?
I have another question. Sorry. If anybody else is there, let them go first, but if not, then I do have another question.
I have a question that I just put in the chat box. I just read about the next of kin law, and I want to know how is that new and why is this next of kin law just developed?
Kin law, I'm not familiar with that.
Next of kin.
Next of kin pertaining to what specific issue?
Well, it says the state is not deferring to next of kin on medical choices.
So,
Article just came out this week.
so again, I think you're typically referring to what a social worker may need to look at. Who is the hierarchy of care, who makes the decision if you are unable to make the decisions and you have not designated specifically a person. Like I said previously, typically the first person that we designate is usually the spouse. After that, sometimes it may be, then it goes to, I think, then your parents if they're still alive. And if that's not available, then it goes to your children, the eldest child. And after the child, then you look for you look for siblings, brothers and sisters. So there is a hierarchy of who can make those decisions. Sometimes go ahead, ma'am.
Yeah, thank you for clarifying that. But according to this paragraph, it's so that U.S. adults either have, let's take it back. It says that it's to empower representatives to advocate for patients rather than allow a hospital to make medical decisions.
Sorry, clarify. What was the question?
So the question is, how is this considered new? Because it says that this law will empower the representatives of the patient over decisions made by a hospital or medical group. So
I'm not sure what, the law, I'm not familiar with specifically the law itself, but I could just tell you what we typically look at. Sometimes it becomes very tricky, though, if, say, you look for the spouse and maybe the patient and the spouse has been separated for quite a long time. Then it becomes very complicated if you've not designated, say, someone in a durable power of attorney. That's why these documents always need to be reviewed routinely, because if your marital status changes and you have not changed who's to speak for you, we may look at a spouse that's that's been separated for many years, and we've occasionally had where a patient's girlfriend and spouse actually worked together. They knew each other and they were pretty pleasant to each other, and they both made the decision conjointly. So again, I think they've been trying to create some type of pecking order on who makes those decisions. I think that's what you're referring to.
well, in this case, it's a pecking order between the patient's advocate versus the medical groups. It's not among the family.
Well, I think what it may be is that the doctor can advise the family what to be done if there's no one, if no one wants to speak for that patient. Obviously, a doctor's opinion or the medical profession needs to also give their opinion on the survivability of a patient if they're in pretty dire straits in the hospital. But a doctor typically tries not to override a family's wishes if it comes down to it.
Do we have any other questions?
Thank you.
Oh, thank you.
Yes, I do have another question. I've never dealt with this kind of situation referencing or along the lines of trusts and so. Do you offer free consultation appointments? Or is that a part of the practice? Or I don't know anything about this.
That is, yeah. So we offer free consultations. I mean, that's one of the joys I like doing, just meeting people and educating people what a trust is or will, and then just
Right.
giving that free education so then you can make the best informed decisions, what's best for you or your family. So yeah, we definitely do offer free consultations.
So we just call your office then and make an appointment to see you pertaining to the creation of a trust?
That's correct. Yep. Yeah, just call and I'd be happy to speak with you directly.
Now, in the course of trusts, I know that there, in the revocable living trust arena, I've heard references pertaining to this, but being a living trust or a family trust. Are these interchangeable terms, or are they separate and different trusts? Family trust or living trust or revocable trust?
Yeah, that's a great question. Yeah, they all do refer to the same document. So people have different names, like you mentioned, revocable trust, living trust. So they do all refer to the same basic trust.
Thank you.
Yeah, of course. Great, and then looks like there's another question.
It's a simple, do you want to read it?
Yeah, it says, in respect to a trust, is it simple to add or delete beneficiaries if circumstances change in the future? How can I make sure that certain family members, however distant, will never contest or receive anything? Yeah, so it is pretty straightforward to amend your documents. You don't really need to create a whole new set of documents. Normally you could do a simple amendment. Normally it's like 2 pages, so it's really quick to if you want to make changes to your documents in the future. And also you could lay out, I think it talked about making specific wishes, so you want to ensure certain people aren't in charge of your trust or receive anything. You could write that in as well. And then making sure it's done correctly is the best way to make sure certain family members don't receive something. So, and then, yeah.
Great. Thank you.
So any questions from the audience here?
Do we-
Power of attorney versus successor trustees. I think there was two.
Okay. So what's the difference between a power of attorney and a successor trustee?
Yeah, that's a great question I get answered a lot. So a successor trustee is the person in charge of your estate when you're passed away. So that's when you're actually dead or deceased, and then you need someone to basically handle your estate, liquidate your assets, and then basically distribute the assets how you've chosen. And then power of attorney is more like, let's say you're in a car accident and you're incapacitated but still alive, and so it needs to help pay bills, to recover, or let's say you're in the middle of signing a contract, like selling a piece of property, and someone needs to help sign that agreement on your behalf. That's where power of attorney comes into play. So they can't be the same person. They do have similar powers. It's just, like I said, the distinction is successor trustees when you're gone, and then power of attorneys while you're alive, but it's still incapacitated.
Thank you.
Yeah.
Do we have any other questions from the audience?
How much do you charge for a trust?
Yeah, so we charge a flat fee for a single person. We just charge $2,000. And then for a married couple, we just charge $2,300 basically for all the documents, the trust, wills, power of attorneys, all the recording and notary fees.
$2,000 for a single person?
Yep. Uh-huh.
And then once you have a trust established,
Mhm.
do you put all the bank account in the trust?
Yeah, no, that's a great question. So yeah, normally we will prepare the deed to transfer your primary home to trust. So we take care of that for you. And then you'd actually go to the banks, and then you'd transfer those into the trust name. And then we'll help you fill out the paperwork. It's just if I contact the bank for you directly, they won't allow us to change the accounts around. So normally, yeah, the person that's creating it, or the person that is created for it, they'd have to go do that themselves. So.
Is it better to put the money in the trust?
Is it better to put the money in a trust?
Yeah, it is typically. So if you put a bank account in trust, then you give your trust liquidity in case when you pass away in the future, your estate needs money to pay bills. That money is available to your trustee to pay for those type of things. So I recommend either having some beneficiaries on accounts or putting some of the assets into the trust name. So yeah, I'd do both. Yeah, but any
Great.
other follow-up questions like that? Or?
So which do you recommend
Mhm.
if you're a single person
Yes.
and you haven't even thought about what
So-
to do
So the question is, what do you recommend if you're a single person? What should they do?
as far as your financials and your medical, if you don't have anyone?
Oh, like don't you think of that help you or?
Mhm.
Yeah, I mean that does come out into play. A lot of times there are professional fiduciaries. I don't know if that's what you're referring to, but there are actually people that's their job. If someone doesn't have family members, we do encounter this. Like if they're out of the country or they don't have anyone they trust, you could actually appoint a professional fiduciary to basically handle your estate or be in charge of your power of attorneys for financial medical decisions. So we do have people you can recommend, or you can find people how you normally find people. So, did that answer your question? Or perfect, yeah.
Great
So,
question.
yeah, so it is an important role. So yeah, typically we see their children do it or family members. If not, then yeah, we always normally recommend like a professional. A lot of times people ask, can the attorney do it? And the answer is normally no. So normally I can't like act as in my own documents. So sometimes I get that question. So, but we can certainly help people. So like if we draw up the documents and people need help, a lot of times those people come to an attorney and they can walk them through that process.
Great, thank you. Do we have any other questions from the audience or folks online?
Question comes.
Hello.
Hello.
Hi. I do have a question. My mother, who is a resident at the ACC, I have power of attorney over her, and I've seen her trust, and it's over 30 years old. So I imagine there's a lot of updates or maybe amendments have to be done to it. Do you offer a free analysis of that trust to see what else is required nowadays? It was done quite long, back in 1980, I think.
We do, but honestly, if it's that old, normally we do restatements. Basically, it's all new documents that are up to date with today's laws, but you can use the same trust names. So for example, if all the accounts or the house is already in that trust, you don't have to go and fund it with all different trust names. So lots makes it easier so you could have a new, all up-to-date trust, but keeping the assets, you don't have to go and change them all. So honestly, that's what I'd recommend if a trust is over like 20, 30 years old. But we'd be certainly happy to review it and then let you know what we'd recommend.
Okay.
Jacqueline, you want to read it?
I have 401ks and IRAs with my trust as beneficiaries. I don't have my glasses on, so I can't read this.
I heard this is a no-no because of taxation. What is your view?
Yeah, so I've spoken with a few financial advisors, and they all agree on that point, and I have done research on this topic as well. So yeah, it is correct. Normally, you'd name individual beneficiaries on your IRAs and 401ks, your retirement accounts. So normally a person could roll that over, for example, to their own inherited IRA, take distributions in the future, versus the trust inheritance, and it's taxed as a full distribution right away, and then you lose a lot of those tax benefits. So yeah, I have set up estate planning for financial advisors, and they agreed on that topic. So I agree with that statement as well.
Great.
Do the named beneficiaries of bank accounts work and not required to be included in the trust document?
Yeah, that's a great question as well. So yeah, anything with a beneficiary does work. So if you have a beneficiary on an asset like a bank account, those don't need to go through probate. And also another question that people ask is, what takes precedence, the trust or the beneficiary? And the answer is the beneficiary. So let's say your bank account leaves a beneficiary to someone that's different from the trust. That beneficiary on the account will take precedence over what's written in the trust. So sometimes people like to do a mix and match of two, like where they're like, oh, I'm happy with these accounts have beneficiaries, but some assets I want to put in my trust and I want to direct where it goes. So yeah, that's a great question as well.
Great, thank you. Do we have any other questions from the audience or people online?
Actually, I have a question.
Oh.
Is a will the same as a trust? Do you need them both?
Normally a will is like a trust, but I think we mentioned the main difference is a will. Someone has to take that will to court still to get processed in front of the judge. So that's the main difference. If you have trust, there's no probate, no court involved, the state doesn't involve. With the will, that does have to go to the state. But yeah, it does sort of act as the same role where you're directing who's going to be in charge of your assets and where you want it to go.
I have a question. What's a reasonable amount of time? When I filled out my advanced healthcare directive, I checked that box, so it was sort of the moderate position, but I wasn't quite sure what that means.
Yeah, so I think Jacqueline's referring to in our advanced healthcare directives, we lay out some factors where people would want to end life support, so we normally do like discontinue after reasonable time. So that was going to be one of my questions, like how does that actually interplay at the hospital where someone has that form on file and then someone's brought in and they don't have capacity? Do the doctors actually go to the form, or let's say people have different opinions on what should be done? How does that actually interplay at the hospital? Do you know?
Well, typically, we try to give a medical opinion or discussion to the person that has the durable power of attorney for healthcare decisions, who has the healthcare directive, and explain to them, what is the medical situation? Is this something they're going to recover from? Is there someone that is going to be in long-term care? As I spoke to before, one of my jobs was actually becoming a medical director of what we call a subacute care unit. Occasionally a person may have a severe stroke, and the family is not ready to let go of that person. They feel that they may recover. We try to give them the best advice on the chance of recovery or the chance to return to a quality of life that the patient may want. Sometimes we go all the way from a person that has had a stroke and the family would look at you and say, look, this is my husband, his life is hunting, camping, going out and fishing, and if he can't return to those things, he would not want to continue on in some type of long-term life support. But also we get the other discussion, we say, look, I don't care what you're telling me, but I would want my family member to live as long as their heart is beating. And occasionally we've had people on life supports for years without that patient fully recovering. So that's where sometimes in subacute care units, we've had patients there on life support for many years, but that is a family decision. And we do try to make that with some medical advice, but we do have to listen to that person's family.
So I should communicate my wishes with my family and make it clear and fill out that PULSE form so it can work in unison with my advanced healthcare directive.
Yeah, and also that's where also, like I said, in addition to all these forms, it behooves that person to do that, like this 5 wishes. What is your life goal? What would you want done if your time became, if that situation arise? That's where it's a good family discussion, saying what you would want done, or what, instead of letting that person try to, guess what you would want done. Because obviously most family members would say, I would want that person to live as long as possible. But is that your wish that you're on some type of life supports indefinitely? That's a discussion that you need to make known to those loved ones.
Yeah, we plan in life, so we should plan in death, so we can have our wishes followed. Sounds good. Do we have any other questions? Do you guys have any questions for each other? I know you're all family.
I have a question.
Oh, great. Thank you.
I have a question. Can you hear me?
Yes, we can hear you.
If a person has a durable power of attorney, the financial durable power of attorney, do they have to be incapacitated before, like in my case, my parents have one, do they have to be incapacitated? Do I need a doctor to say they're incapacitated before I can take over?
Yeah, so that's a good question. So I've normally seen, depends on the institution. So normally, if you try to use it like at the bank, for example, or sell a property, a lot of times those institutions will want to see a doctor's note before you can take over. So like I said, it's really hard to say one way or the other. It just normally depends on where you're trying to use it and what that institution requires.
Okay. Now if the property is in a trust and the children are trustees, then we can go ahead and do the financial transactions if we're trustees.
I had that similar circumstance just come up. So, for example, the person was trying to sell the parents' house, and they were successor trustees, and then they were going to go talk to the title company and still.
Well, actually, I didn't mean success. Well, we're a trustee on the just like my mom. Well, we're on the top line as trustees, even though our parents are alive.
Yeah, so then, it normally depends on the document if only requires one trustee to sign. But normally, if you're already a trustee, you could sign on behalf as the trust.
Okay, okay.
Yeah, but like I recommend, normally I just run that by whoever you're working with, like the title company, you just show them a copy of the documents and give them the circumstance. And a lot of times you can pre-plan ahead of time just so you're not at the end where you're about to close and they're like asking for certain documents. So that's normally what I recommend in these type of transactions. Great.
Yeah, there was something I read somewhere. I wish I thought about the question before this, but I think it was in Scotland or one of these places in Europe where they were talking about, I guess when they had Alzheimer's or something, and they were talking about it was a different document, and I don't know whether, and it was for someone else to speak for you when you can't speak for yourself anymore. And I wasn't familiar with that term that they use, but doesn't the standard, like, just the durable power of attorney?
Yes.
I guess you said the durable power of attorney
Yes.
doesn't work unless they give their permission.
No, that's the question.
So I guess, is there some other form that you do, so that when the dementia gets really bad and something isn't under the trust, that you're able to then, handle the transactions? I forgot, there was a certain term for that over in Scotland or someplace, and I don't know if they have that here, because it was the Alzheimer's Association over there that talked about that term. And I saw it on some of the presentation.
Typically, I think the question is that at what point is a person no longer able to speak for themselves or incapacitated enough? And in the medical profession, sometimes a doctor may feel comfortable enough to do that, say as the person has a major stroke and is able to make those decisions. But sometimes in terms of Alzheimer's disease, or if you have some type of psychological or psychiatric problem, a neurologist or a psychiatrist may have to make that decision that that person is unable to understand questions or unable to speak for themselves. Then they need to have someone like a conservator. Then you discuss that. Conservators, at what point is that person unable to make healthcare decisions, unable to make financial decisions? And that's becomes a little bit more of a medical legal type of discussion.
Mm-hmm. So is that why if you have something under the trust, you don't have to worry about that when it comes to financial? If you're listed as the trustee, that's already taken care of. It's only if something is not under the trust, I guess, and you're trying to go this power of attorney route, that's when there's a problem.
It can be, but I'd honestly recommend doing both, so having the trust and the power of attorney just to be safe. Otherwise,
okay, because I know on some like bank, where's I think one bank account we have, I guess, the children's names and the parents' names on there, but everything else is under the trust. Yeah. And I remember the attorney was saying that we shouldn't put that much money in the account that's not under the trust, and I guess he didn't really give an explanation. He just said you should have less than $30,000 in there, but I didn't understand why.
Mm-hmm. Yeah, I mean, if you're jointly on account, for example, then normally you don't need power of attorney and access account because they're already on that account with the person. So,
okay. But if one person dies and you have this joint account, then aren't the assets supposed to be frozen and you don't have access to it?
It depends on banks. A lot of times you just provide a death certificate, and then if there's a joint person on it, just go the joint survivor on that account.
Oh, okay. Thank you.
You're welcome.
Great.
One question. Oops.
Hey, go ahead.
Okay, I have several properties, but they all have payments. In other words, they're not paid off.
Uh-huh.
Can these be included in a trust?
Yes. Yeah, so the property doesn't, that's a great question. So the property doesn't have to be free and clear to put into the trust. And it doesn't affect the loan. So yeah, I mean, the mortgage isn't going to care if you put your property in the trust because you're still the owner of the trust. So that's why, you could put properties that still have liens on it into a trust.
Thank you.
You're welcome.
Do most people have one or two power of attorneys, one for the financial and then one for medical? Is it usually one or two power attorneys that most people have? What's the common?
Yeah, no, it's two separate documents. So one power attorney for financial and the advanced health directives normally for medical. Mm-hmm.
Two.
Yes.
So there can be multiple people in charge of making decisions for you.
Yes.
Okay, great.
Do you have a story to share of somebody that doesn't finish their trust and even a donation could be lost because of that, or just?
Yeah, well, we can go on that. I think you had a question back there.
I'm sorry.
Go ahead.
You touched on the Medi-Cal long-term care. Now, how does that, do you know much about that? And if you have accounts, how do you qualify for the Medi-Cal long-term care? Yeah.
So Medi-Cal long-term care, it'll cover nursing home care. Only Medi-Cal long-term care is only nursing home care. It's based on your income and assets. Some assets are allowed under the Medi-Cal long-term care. So in general, they allow you to have your home and a certain amount of assets you can keep under your name. But it is a poverty level program, so you have to have a certain amount to go below before you're allowed to apply for Medi-Cal long-term care. And people ask me too, can you kind of pre-plan for that? You can kind of pre-plan in the way you can kind of see how many assets you have and what's exempt and not exempt. But you can't really apply for Medi-Cal long-term care until you actually are already in a nursing home.
So I just didn't know how that affects, if you already have like a trust and you're saying, you're deeding to your children or whatever, why that would supersede, or, they would not allow that to happen. You have to be at a poverty level to be in long-term care.
Yeah, I mean, so you do your planning, so things in a general trust, it doesn't exempt your assets from being counted for Medi-Cal long-term care. There are some special ways to maybe shelter some of your assets. That's not something that I do personally, but there are ways possibly to shelter them so that they aren't counted. But a general trust will not shelter them, so they will count that as part of what you have to see if you qualify.
Okay, thank you.
You're welcome.
So
Yeah, I also have a question in that regard to the Medi-Cal qualifying for that. I believe there's a 5-year look back. That's what I was told. And I've talked to an attorney before that did trust too. And, thinking about, again, going back to my mother who has assets, and I was told that there are special trusts you can do to take the assets my mother has and put it in an outside trust that's taken out of my mother's assets. And therefore, that would qualify her for Medi-Cal assistance. But I guess you don't do that type of trust, is that what I understand?
Yeah, we don't do as many of those. Yeah, I know there are those medical asset protection trusts. They're more specialized. So yeah, honestly, that would require, meeting with individuals to specifically go over the wishes to see if that's a good fit. And then, yeah, there are other attorneys that's really what they specialize on. So that's correct.
what about legacy giving? If I want to gift something, how do I do that?
Yeah, so legacy giving can be done in a trust. A lot of times we create these trusts and people want to give a certain percentage of their estate, to a charity that they're familiar with. I mean, we do have clients that do have ACC or like the zoo. So those can be put into your part of your estate plan. So, and I guess there's a question there. It said,
You had a good story about a client.
I said, there's a question on there. Helen?
Did you want me to read it, or?
That'd be great, thank you.
Okay, so what did you say was the name of the government program that pays for assisted living? It's called the Assisted Living Waiver Program. And like I said, you can look at the Department of Healthcare Services website and it'll explain it. And it's just, like I said, unfortunately, it's kind of limited in nature. So it's not going to be covering everyone on assisted living. So unfortunately.
And all of our slides will be available, and on there are resources along with our contact information if anyone has any more questions.
yeah, it looks like a question there that says, if I still have a mortgage and I die, what happens to mortgage and expected beneficiaries without a will or trust? Does it somehow get paid off? Yeah, so normally in a trust administration, that gets paid off first, and the net proceeds are divided up in a trust. So that's normally what happens. I've seen some people try to assume the loan or get a new loan if they want to keep the property. So those options are available. I know it's a lot harder in probate. If there's a loan on property, is that correct? You've seen where the property has to get sold if there's a loan? Have you seen that in play? Or?
Oh, so if it's in the...
If you went through probate and there's a loan on the property, isn't that harder to keep the property? Or?
Yeah, because it's going to be divided among potentially multiple beneficiaries. So to have to agree on a loan among more than one individual sometimes is difficult. So a lot of times then, yeah, they will determine it's in the best interest to sell the property.
Right. Okay. Well, I think
Great.
that's all the time.
Yeah, that's all of our time. Thank you so much.
Thank you very much.
Thanks for having us.
Thank you all.